Hi, everyone. I see people coming in. Thank you so much for joining our webinar today. Maybe we just give a couple of minutes for people to trickle in. In the meantime, what's the weather like right now in Boston, Jihan?
Oh my gosh, don't even ask. Just kidding.
Bad?
Actually, you know what? I think that's just my default response. It's actually beautiful today. I actually had I'm in my basement. But
Okay, that's nice.
I went outside today. That's so funny that my brain immediately went to like, don't even ask me that question. But it's beautiful. Oh, it's raining now.
It's raining in San
It
Francisco as
just
well.
started raining. Oh.
Yeah, and in Palo Alto, which is very unusual for Palo Alto to rain in May. It's like it just never does. But the weather is changing all the time. Okay, great. I see a good number of people. I'm impressed how everyone is on time. Amazing. Thank you so much for everyone confirming. Really appreciate it. I am Aizada, CEO and founder of Alma. Alma was founded from experience. I left the United States twice because of my immigration situation. And the third time is a charm, and I married an I'm a green card holder, and my immigration case was mishandled, and I was stuck inside of the US and couldn't work for 1.5 years. That time, I was just really thinking, I'm an attorney. How can this be happening to me? So then I understood actually it's a bigger pain point, and that sparked the idea of Alma. And as they say, you can only connect the dots looking backwards. So this was my aha moment when generative AI happened, that I want to start a company that actually solves immigration problems, even though I was a corporate and finance attorney before. And I love immigration because it touches humans' lives. And if we can make someone's life better, that feels to me more than when I used to close transactions for like 500 million. With that, today we're going to be talking about immigration one-on-one. And I know some of you are more experienced and some of you are global mobility managers, but we will be also talking about the immigration landscape and what we see, what are the trends that we're seeing in terms of like what visa categories employers are using these days and how to build a compliant program, because government is unpredictable and we really want to drive value for everyone in the community. And I want to introduce also Jihan. She's an attorney with more than 14 years of experience. She's been all of these years practicing immigration, so she is a pro at it. And maybe Jihan, you just want to say a couple of words introducing yourself.
Yeah, absolutely. So I started out my career in big law. I've been practicing business immigration law exclusively for over a decade at some of the largest law firms. And I joined Alma last year because I'm really excited about about building and within our field and how the technology is transforming our field so rapidly. I mean, for better or worse, like it is changing. It's changing the work that you all do. It's changing the work that we do. And so I wanted to be in the front lines of that. And so I'm super excited to be with you all today and talk a little bit about some of the changes that we're seeing in immigration adjudications and program management. So thanks, great to be here.
Thank you, Johan. Feel free to ask questions at any given point. This is the agenda for today because this is immigration one-on-one, and some of you might be more advanced, but there's also some of the basic things that we need to cover. One is the most common visa categories for employers and when to use each. And then we talk about employment-based green card pathways. Then we talk about steps for building a compliant immigration program from scratch. And then we can talk about how managers can support employees and avoid compliance pitfalls. And then the fifth one is the immigration landscape. And we'll also leave some time for Q&A, but feel free to write your questions as they come in. Sometimes we will just take a pause and respond to them if they're very relevant to what we're talking about, or we might take them in the end as well. So please keep writing those questions. Thank you. And then with that, I give the word back to you, Jahan.
Awesome. So I thought we could just dive right in. We have people joining with a variety of backgrounds. Some of you have been working in immigration for years, and some of you are newer to it. So what I'm going to try to do is breeze through some of the basics. This is called Immigration 101. We have to start somewhere, but we want to spend most of our time on recent developments and information that is helpful for the broader group. So let me just jump into some of the basics. I wanted to lead with some of the most common employment-based visa categories that we see companies use when you are leveraging international talent in your workforce. Oftentimes, this starts with international students, individuals who are graduating and they have something called OPT, employment authorization, that's granted granted typically for 1 year after somebody completes their educational program, and if they're working in a field related to their course of study. If they graduate, if they have a STEM degree, currently they can get an extra 2 years beyond that. Right now, we're going to talk a little bit about some of the changes that might be happening to the F1 program. There's a new F1 rule, but that's going to be something that we talk about in a little bit. The H-1B visa is one of the other most common types of visas. It's a specialty occupation visa for individuals working in fields that typically require a bachelor's degree, and those individuals have a bachelor's degree or equivalent in a related field. The L1 category is for intra-company transferees. So if you are a multinational company and you have offices abroad and in the US, it may be possible to transfer some of your key employees who have tenure, who have at least a year tenure with one of your abroad entities, into the US to work in a managerial, executive, or specialized knowledge capacity. There's also something called an O1 visa, which many of you have heard of. It's an extraordinary ability visa. It's unlike some of the other visa categories. It really is based on the person's individual background and qualifications, essentially documentation showing that they've risen to the top of their field of endeavor as shown through various forms of evidence, publications, citations, presentations, being a thought leader in their field, serving in a critical role with an organization that has a distinguished reputation, things like that. And then there's the TN visa, another very common visa. It's for citizens of Canada and Mexico in specific professions designated under USMCA, formerly NAFTA. Those do offer great benefits for roles that qualify, but not all roles qualify. So if you're in a sales role, for instance, or marketing, there's not actually a TN profession for that. So one of the things we always tell people is it's really important to get. Don't just assume that it's because somebody's Canadian or Mexican that they can get the work visa. Understand what the job is they're going to be doing, get their resume, share it with counsel to do an assessment before you send that offer letter. All right, so that's the overview. And moving on, international students, I talked a little bit about that. The 12 months after graduation, possibly another 24 months. Beyond that, if they have a STEM degree that's on the DHS's STEM list. And this has been historically a very, very, very important part of the international talent pipeline because it allows employers several chances historically at including those workers in the H-1B lottery. So if they don't get selected 1 year, they might have another year before they max out the STEM. And if you do get selected in the lottery and your F1 is expiring, you might qualify for something called a cap gap to allow you to maintain your work authorization before the H-1B takes effect. There's also something called F1 CPT, curricular practical training. That's something that is for individuals who are currently in a degree program, and it sometimes will allow them work authorization while they're completing their degree program. It's a category that has been misused by some unscrupulous employers in the past, so it's something that the USCIS has scrutinized in the context of changing status or adjusting status. So if you're considering hiring somebody on CPT, just understand that you might face obstacles once you're ready to move them onto another visa, like an H-1B. In the past, it hadn't been as much of an issue as it is today, but if they're considered not eligible for the H-1B change of status, that could really expose them to some challenges, especially this year with the $100,000 fee for individuals who aren't eligible for the change of status. Just something to keep in mind. There's a lot of different options when you're considering individuals. If you are hiring an international student or considering an offer to them, it is really good to go to counsel if you don't already have an assessment program built into your own mobility team and ask them to do an assessment, like a pre-hire assessment, just to understand, are they eligible for a work visa? What is the maximum period on that work visa? What other visa categories are they eligible for? If they're on a student visa, are they going to be able to move to potentially another visa? Are they, for instance, do they have the potential? One of the categories that we didn't list here is the E3 and the H-1B1 visa. Those are also specialty occupation visas for citizens of Australia, Singapore, Chile, and so if somebody's a citizen of one of those countries, they might have more options available to them. So pre-hire assessments can be really important. We've already talked a little bit about the H-1B. Most people understand it's a lottery to get into the H-1B the most time, except for organizations that are considered CAP exempt. Those are normally nonprofits, universities, teaching institutions. But for most companies, you do have to go through something called the H-1B lottery. There's 65,000 slots and another 20,000 for advanced degree holders. And one of the nice things about the H-1B category is that it allows something called dual intent. So you can hold the H-1B visa and also pursue permanent residency process, file an adjustment of status process once you reach that milestone, and be able to travel on your H-1B. That has become especially important now in the last week that we've heard about this new adjustment of status policy memo, which we'll talk about, and what that means for people who don't hold H-1B or L1 and changing from other categories, which actually, to be honest, we don't know 100% what's going to happen with that, but something we're keeping an eye on. The O1 category, I feel like we've talked about a little bit. L1, the intercompany transferee. One thing I didn't call out is for both the H-1B and the L1, there is something called a maximum period of stay on those visa types. So for the H-1B, that's 6 years. You have 6 years of time on the H-1B before you need to reach a certain milestone in your green card process that will allow you to extend beyond the 6 years. So typically that is that your perm is filed at least a year before your max out date, or you have an approved I-140 with a backlogged priority date, means that you're not yet eligible to adjust status. Those individuals are able to continue to extend their H-1B. The L1 allows for a 5-year maximum period of stay for L1B holders. Those are specialized knowledge professionals, individuals who are coming with a specific knowledge of the company's, like advanced knowledge of the company's proprietary or company-specific processes or products or methodologies. You only have 5 years available on that visa. You get an initial period of 3 years, and it can be extended for another 2 years. Total 5 years. The L1A visa is for managers and executives. That has a maximum period of 7 years. And just to point out, the L1 and H-1B time, they're considered, the maximum period is cumulative. So if you've held L1 status and you switch to an H-1B, that L time is counted against you, typically when you're calculating your H-1B time. Just make sure you understand when you're talking to employees you're considering to hire, maybe they already hold H-1B status, how much time do they have left on their H-1B, and do they have an approved I-140? Because depending on the answer to those questions, they might not have a lot of time left before they max out and have to leave the country. So the max out dates are extremely, extremely important to understand at the outset when you're considering applicants. L1A, L1B. One of the nice things about the L1A visa is that for individuals who were managers or executives abroad and are also going, managers and executives in the US, they may also qualify for a fast track EB1C multinational manager green card process. And that is in the EB1 category. It tends to be a much faster process to a green card in terms of backlogs than EB2 or EB3. We'll touch on those in a minute. So with that, and then the other thing I love about the L1 is that spouses of L1 holders have work authorization incident to status, which is not something that you see in other visa categories and many others. So H-1B spouses can get work authorization, can apply for work authorization if the spouse has an approved I-140. So that's a little bit different. TN visa, we talked about, that's for Canadians and Mexicans, very specific professions. Employment-based green card pathways. There are 3 basic employment-based green card pathways. 2 of them typically require something called PERM, labor certification. So most people who get sponsored for a green card through their employers have to go through something called PERM, labor certification, which is a testing of the U.S. labor market where the company goes out into the world and, among other steps like obtaining a prevailing wage determination, they go out and advertise the position to U.S. workers in the area of intended employment and attest that there's no qualified, willing, available U.S. workers who have come forward who qualify for that role. In contrast, there are a few pathways that do not require going through PERM. PERM is a very long process. Right now, it's taking at least 2 years in most cases from the start to reaching the ability to file an I-140 petition. the EB1 process and the EB2 national interest waiver, you can bypass perm. So EB1, there's three different types: extraordinary abilities, outstanding professors and researchers, and multinational managers, executives, which we already talked about. EB2 national interest waivers are for individuals. You have to hold an advanced degree to qualify for an EB2, or be a foreign national considered of exceptional ability, which is there's various criteria to meet there. And for the national interest waiver, you have to show that you are working in a field of endeavor that will substantially benefit the U.S. and that you are well positioned to advance that endeavor. It's at this point, in the past, there was a little bit more leniency in approving these petitions. Right now, the scrutiny has definitely increased, and we're seeing the standard of review much closer to something like an EB1A, extraordinary ability visa. But it's still an option for certain positions and certain types of backgrounds. Perm, I-140 adjustment of status. That's the typical three-step process for a green card. The perm, like we said, could take 2 years. If you are eligible for something called an EB1 or an EB2 national interest waiver, you can skip over perm, go straight to the I-140. I-140 is just paperwork filed with USCIS. It can be a lot of paperwork, but what happens is when you file the I-140, it is for filing the perm, will establish your priority date if you're going through the perm process. Otherwise, your priority is based on the filing of your I-140. That holds your place in line for a green card. That's the basic idea about priority dates. Once the person's priority date is current under the Department of State Visa Bulletin, they qualify for adjustment of status. That's the final step in the green card process, which is paperwork filed with USCIS and a lot of information about their background. Retrogression, great question. So every month, the Department of State releases a visa bulletin, which essentially lists the different categories and priority dates that are listed and earlier are eligible to adjust status. They're an immigrant visa. A green card is now available to those individuals. Typically, historically, over time, priority dates advance. They move forward so that eventually people's number comes up. But what can happen periodically is the categories can retrogress. So in other words, they will no longer accept priority dates that maybe they accepted in the past, and they'll move back in time. And in those cases, people who have already filed their adjustments of status with priority dates that were current at the time, their adjustments will continue to pend, but there won't be any new adjustment of status applications accepted. In some cases, there are also two visa bulletins. No, this is like so complex. There's a visa bulletin with a dates for filing chart and a dates for final action, which means the green card is actually available. And depending on the month, USCIS might accept adjustments based on the dates for filing chart, but they will only approve green cards with priority dates current under the dates for final action charts. But long answer to a short question. Priority dates can move forward and backward. So if you can retrogress and no longer be eligible to adjust status, or your current adjustment will just continue to pend until it becomes current again. And that is, the retrogression can happen in either filing dates or the final action dates. But the filing dates chart would only govern the USCIS accepting that application, and they will announce every month which chart they're going to use to accept the applications. So this month it was the dates for filing, and that's going to be the case for the rest of the year typically. But early in the fiscal year, October, November, December, they typically accept more the wider dates for filing charts, so they get more applications in, even though they're not ready yet to be adjudicated. Sponsorship scenarios. I think there's many ways that people go through their green card process, but these are some of the common scenarios. Somebody comes on a student visa, they switch to an H-1B. Somebody comes on an L-1B visa, the employer sponsors them for an H-1B, they eventually switch to an H-1B. Those individuals often have to go through the perm process to adjust status. L-1A holders, sometimes they can get a fast track green card process, like I said, because there's this multinational manager EB1C process. The J1 visa holders can also sometimes switch to an H1B. Have to really look at if somebody who holds J1 status, it's important to check their visa stamp and their DS 2019 to see if they're subject to what's called a 2-year home residency requirement, because if they are, they won't be able to change status in the US unless they get a waiver or they spend 2 years abroad back in their home country. So So another just call out different scenarios, different ways to go through the employment-based green card process, but this is something that we see. When to start, I'm planning somebody's green card process. I think a few years ago when I was practicing, it was like, okay, a year before the person's max out date. We are no longer there. Now we're telling people minimum 2.5 years before somebody maxes out, do you want to start considering sponsoring them for the green card process if you want to avoid a gap in work authorization. There's so many things these days that can trip up companies, that can trip up people going through the green card process. Their job changes, location changes, you get a higher prevailing wage than you expected. The perm recruitment doesn't go as you expect. We're not going to spend a lot of time talking about the perm process, but there's a lot of things that can happen in a perm. So the earlier a company can start that for an individual who does not yet have an I-140, the less likely they're going to encounter a gap in employment authorization. So my overall advice is to set expectations early on with the business that the person has, X max out date, and that what this means in terms of their risk and what their options are. So somebody, for instance, for somebody from a multinational, company, they might have the option to do an assignment abroad. They might have the option to switch to another visa if they're holding, some country specific visa, based on nationality. So just understand what those are and you can set expectations that way. I wanted to pause there because I've just been talking nonstop to see if there's any questions that anyone has. I won't, because we're going to switch gears and talk about building a compliance foundation. But because I've been talking so long, and Aizada, let me know if you disagree with me. I would love to take a step back and talk about how foreign nationals can be supported, even if you, as a global mobility professional, are not an immigration expert. Does that sound okay?
Yeah, absolutely. So do you want to talk about compliance later and I talk
We'll
about?
just come back to the compliance. Yeah.
Sounds great. I mean, I know it's a lot of information, but I also a lot of, attendees, they're pretty experienced, so that they know all of this information. I'd like to focus on how you can actually improve your immigration program, maybe slightly or maybe significantly, depending what's the state of your immigration program now. And this is based on us having talked to more than 100 global mobility managers, chief people officers, and immigration specialists at companies of different size. So baseline, they're like low-hanging fruit that you can just quickly change. So there are a couple of things that we wanted to share with you. There are like 3 things. First is like how you can demand more from your vendors and what you can do, and then how you can use technology to absorb some of the manual repetitive tasks. And then the third one is managing the expectations. Essentially, how you can provide a better support without getting involved too much into immigration. One thing I would like to say that I know a lot of global mobility managers have paralegal background, and that happens to be pretty handy when you're managing global mobility programs. But also at all times, what is important to understand that now you're doing slightly different job. Now that job, it belongs to the law firm and you are responsible for achieving company goals and showing some business impact and ROI on the immigration program, return on investment on the immigration program. And what usually companies care right now a lot is that how you can like frame immigration as a benefit, right? Like if you think of like companies all compete in benefits, like even at Alma, we're like, oh, we do this, we do this, we do this. But if you ask from immigrants, what's the highest benefit company can offer you? It's an immigration support. So immigration as a benefit helps company attract best talent, helps company retain best talent. And your job, it actually like all of your internal stakeholders are happy with you. So to do that, the first thing you can from day one just demand more from your vendors. And the reason why is that immigration landscape is changing a lot. It's no longer companies, law firms can be comfortable with how they used to do things and they think, oh, this is how we used to do things forever. Does not matter. Raise the bar because AI is putting so much pressure on everyone. And I think all the global mobility managers and everyone who's supporting foreign nationals at companies, they need to stay very close to what the company goals are. Attend all hands, listen what the leadership is saying. If it's a public company, read the reports, understand what's important for the company. And then if it means that you need to apply more pressure to your vendors, do it, absolutely, because they can no longer be complacent and say, we used to do things this way. Doesn't matter. There's so many companies like Alma, similar to Alma, many more who are trying to disrupt the immigration legal tech space. And we're saying the old way of doing things is not good enough. So demand more from your vendors because the options are way wider these days. So first one is that in the light of these regulatory changes, when news are coming all the time, and then there's a lot of anxiety with your employees, when your employees are anxious, you're going to get emails at any hour. You're going to get emails over the weekend. You're going to get over the week. Some might even want to escalate things. So you need to ensure that your law firm does monthly, or even when something is being announced as big as AOS, they should be able to do a town hall for you right away. And many companies do it. So if your vendor is not doing it upon your request, you should force them to do it, and they should do it, period. No negotiation there. You need it, they deliver. The other one is about proactive alerts before deadlines and not reminders after, right? Like today, like we know that like Department of Justice created this entire enforcement unit on immigration. So they've launched investigation Lodera. It's a public information, but they're launching many more investigations. So what do you want? You need to put extra pressure on your immigration vendor to be alert and to notify you of everything that concerns deadlines, expiration dates. That's their responsibility. That's not your responsibility. So maybe in like for the beginning, you just sit down with them and you say like, let's revisit that relationship. Like these are the things that you need to do for us going forward. You just must, because everything is changing so fast. And then the other thing is understanding and enforcing strict SLAs. This is becoming a norm more and more. Many companies I talk to, they are becoming stricter with SLAs because time to seat is so valuable. If you're fighting and competing for talent, and all the companies are now like compete for top talent, and their organizations, we all know, I will not name them, they are like overly compensating. And if you lose on a talent, if you don't get back to talent fast, like time to seat, right? Like you made them an offer, it takes forever for them to get started. You're going to lose them. So many companies are hearing the employees are like, they get one job offer, but they're still interviewing and getting other job offers. They might not be there when you sorted out their immigration stuff. So enforce strict SLAs and make sure time to seat shortens significantly. You put a start date and you say, this is non-negotiable, they need to start. And if you're doing premium processing, then you can control a lot of things. The other thing is that what we are seeing more and more is that getting rid of the generic emails where you can email and you don't even know who's the owner of the relationship, so that like you need responses to be the same day within the first 3 to 5 hours max. If you're emailing, they need to get back to you. So you can keep the generic shared inbox, but you should also have specific emails, and people should be held responsible for the response times. And you should also tell them, going forward, we are going to also track what's the response time of your vendor. Essentially, it's the TLDR is that demand more from your vendors. You can get more for the same money that you're paying, because the landscape has changed. This is no longer anyone can be comfortable with the way how they do things and just think this is good enough. Nothing is good enough. Raise the bar constantly. The other one is about use technology to absorb the repetitive questions. This is super important because when you think of your job as global mobility managers, HR specialists, people ops teams, what's important is that you, at a lot of these companies, by virtue of my job, I listen to a lot of podcasts with CEOs of many companies, and then constantly on Twitter and on podcasts, they're saying use of AI is becoming almost a performance metric. They all demand from everyone to adopt AI, right? So you also need to show some proactivity there and show some of the things that you've accomplished. One of them is like AI chatbot that trained on your company's specific policies and visas, and you just build it and you share it, and then you're like, I've used AI and I've implemented AI. Like check that box. And if you're interested, please reach out to us, because we held a workshop last week. We can share the video materials, how you can do it at your own pace at home. The other one is really like creating a lot of self-serve resources hub about the timelines, FAQs, document checklists, what they need to know. The other big thing is that what I'm seeing more and more companies doing is that their HRIS is integrated with their tech platform of the law firm. So HRIS connected to the tech platform of the law firm, so that nothing flips through. So you don't want H-1B amendments happening like, reactive after something has changed. Someone moved from, let's imagine, San Mateo County in California to Santa Clara County, and now a person is, needs to get an H-1B amendment because Santa Clara salaries are significantly higher. So those things happen, and then you need to put a person on a paid leave because, now you need to get an amendment. All of those things these days can be automated with technology. So we're seeing more and more companies just table stakes asking us, does your platform integrate with HRIS? Because we want to keep everything in the loop. We want data to be accurate anywhere. And that's what I'm also seeing a lot. So you should also work on this as well. The other thing is about audit logs and being able to report on your data. So more and more companies, they want to build the reporting themselves. They don't want to ask their law firm and the law firm to get back to them in a week. A week in the age of AI, it's a month. Your leadership, if leadership asks you something, if they basically ask you how many people are impacted by the AOS news, you got to be able to share the information right away. They no longer wait. And as a CEO of a company, I'm sharing this. I'm also like, if I ask something, I want it immediately. That's how usually the leadership works. So you want to be able to meet the leadership demands. So you need to tell your providers is that, hey, I want to see it. You cannot be just doing, even if you're doing everything the old way in spreadsheets, tell them. If you're using Google Drive or Dropbox, you're like, hey, I want all the reports being updated live and I want to get access to it. Like now, I don't want the reports to be when I request, you send it to me in a week. I want to see it in box that I can access at any given time. You just got to put it in the name. It's like when it was last updated, but I want to see and I want to have this access right away. So essentially it's like you want to have more control, and that's what your leadership wants from you. And that's your job. Your job is not pushing visas day to day because your leadership thinks we're paying this huge bills to our law firm, like they're pushing the visas. What are you doing? So that's your job, is to manage the workflows, create the processes, and demand more from your vendors. And I think the one thing it's also super, super important is setting the right expectations internally. When I ask a global mobility managers, HR experts, CPO teams, I'm like, what do you think your leadership thinks you're doing with immigration, right? And their responses vary every time. And some saying like, oh, like I think that they think that I do visas. And I'm like, okay, so you need to like actually clarify it and explain that you're the program owner, that you're not the legal expert. The legal expertise, legal advice, someone needs to bear the liability for. It lies with the vendor. If something goes wrong, that's what law firms are created for risk. And then you're like, my job, I own the program and I ensure that the company goals are achieved. And these are the company goals that I'm tracking, and I'm making sure we're, as a company, accomplishing all of our goals. And then you explain that like your vendor handles the law, you handle the workflow, and then employees should hear from your vendor directly for case-specific questions. Forget that you need to triage. Like this is not value add for no one. If employees reach out to you and they're like, hey, my lawyer is not responding, and then you're reaching out to your law firm because they only respond to you, well, leadership sees little to no value in that. So stop doing that and tell your vendors, this is one metric I'm also tracking, is that your response times to me, but also to our employees, they need to handle it. And then what also you want to know is that for the leadership, you're like, this is what I will be reporting on. This is the budget, the timelines, risk picture, but not the visa categories. You don't want to explain the visa categories. You just want to explain how immigration program is creating value for the company and why immigration program has a right to exist. So I'll pause here, Jihan, so that you can take the next slide.
Sounds great. There was a question from Miles about how AI is transforming professional services and the law and sort of how we're thinking about it. Is that, do you think that this, I mean, this is sort of what we're going to get to at the end, but do you want to address this now or save it for the Q&A?
And maybe I'll just address it quickly. I think AI role in immigration specifically. Yes, I think it's like we all know that AI is changing white collar jobs significantly. I was a lawyer myself at a big law firm, and then I was a consultant, and I saw it live, and I'm seeing it live how the profession is changing significantly for lawyers. We are able to do things way faster. We are able to automate low value tasks so that the attorneys actually act as a true partner. Like when I used to charge billable hours to my clients before, I'd always like, my clients were upset if I did like something low value because they were like, why are you charging me $1,000 an hour? And then you're like basically doing some very basic job. Don't do. I'm paying you $1,000 an hour so that I get your strategic advice. that impacts the business. That's why I hired you. And I think we follow this similar approach at Alma. It's like visas are going to get done, right? We're going to get them approved. Employees will be happy, but the strategic piece of it is more important. And that's where we are trying to free up our attorneys' time so that they can spend more time with clients thinking about the strategy piece. So maybe then now, Jihan, let's move to the compliance foundation.
Sounds great. Yes. All right. So let's jump into some of the compliance pitfalls that we see employers come into contact with when it comes to immigration law. So I-9 program, hopefully everyone's aware about what the I-9 is. Every employer is required to verify their employee's identity work authorization. At the time of hire, it has to be completed within 3 days of employment, and it involves reviewing their work authorization documents. What we are seeing in the immigration space is that ICE is running audits when it comes to I-9s. And this can be triggered by a worksite inspection. It can be triggered by something that comes up in their data. Penalties for that start at, it can be thousands of dollars per violation. So at scale, it could have a large impact on the company if it's not something that you're paying really close attention to. Also, LCA and worksite compliance is becoming especially important when somebody's work location changes, even if it's seemingly temporary location, even if it's just their home address. And these days, a lot of people are spending part of their time working from home. That employer, you need to assess whether an amendment is required for their work authorization. If they're holding an H-1B E3, H-1B1, they're going to need a new LCA and potentially an H-1B amendment before they start working at the new location. There's also this thing called a public access file. Every employer is required to maintain one for individuals, for employees on H-1Bs. It's not optional. It's the first thing that's requested when there's a site visit, when there's a USCIS site visit. You have to maintain the labor condition application, which is part of the H-1B petition, wage rate documentation, actual wage memo. This is all information in a package that the law firm should be providing you as part of the H-1B preparation. But it is important to audit your existing public access files periodically. This is where we see some people come into trouble. They don't have the most up-to-date information in the public access file, or they don't know, or they're using a system where they're like sort of paper filings. They don't know exactly where they are. So you need to know if a USCIS officer shows up at the place of employment, that people are aware who they are, who is going to be the person that they talk to, and what the protocol is for that kind of site visit when somebody from the government comes knocking. So the other issue that comes up is around terminations and changes of status. When you're terminating an H-1B employment, you're required to notify the employee, but you're also required to notify the government. And you have to notify the employee of their right to return transportation paid for by the company. So if their H-1B employment ends before their expiration date, then the company has to pay the reasonable cost of return transportation if the employee will be returning. If they will be staying in the US, for instance, and switching employers, that's another thing, but you do have to offer it. So the notification to USCIS is something that people ask a lot about today, because in this administration, we have seen the government increasingly send notices of request to appear in removal proceedings to certain H-1B employees who are terminated when the government receives the withdrawal notice from the employer. This is still relatively rare, but it's coming up enough that companies are thinking about, when do we file the withdrawal? And you're really stuck between a rock and a hard place, because if you don't file the withdrawal in a timely manner, it can expose you to back wage liability. If you do file it within the 60-day grace period, the person can be put, it notifies the government in a way. So what a lot of companies do is they make their own internal risk assessment. And some companies say 30 days. We'll give them 30 days and then we'll file the withdrawal request with USCIS. That'll give them a chance to at least start the process of looking for another job. Hopefully they'll have something filed before they get some sort of notification. This is still, again, relatively rare, but it's enough that some companies are thinking about what they're going to do when they have to unfortunately terminate somebody. Another piece is, what what do we offer employees that are terminated? Sometimes they're on their own. Other times you offer a termination call with counsel. Some counsel will charge extra. Alma doesn't charge for that kind of thing, but it is something that you can give to them and let them know, hey, these are your options. This is the impact to you. These are your obligations as you're moving into this next step in your life. We're talking a little bit about where compliance breaks down. Benching foreign workers. So that's another way of saying there's not enough work here for you, but we're going to keep you on an H-1B, but we don't really have any work for you to do. That's not, you're still required to pay your H-1B workers their full wage rate on the petition, even if there's no work available to assign to them. So furloughing or benching them is a wage hour violation under the LCA. You can't just take them off payroll because there's not enough work. That's sort of an area. And so the question of unpaid leave, if it's a legitimate unpaid leave under something like FMLA, that's something that's permitted on the H-1B. But if it's just based on a non-availability of work, that is going to be a violation. So make sure you clear that with counsel if you're considering putting somebody on leave. There's also worksite changes to keep in mind, office relocations, return to office policies, when somebody changes their home address. All of these things could trigger LCA requirements or H-1B amendment requirements. Make sure you're not operating in a silo and just treating these as basic HR events, and make sure that your systems are updated, that there's a process for notifying counsel. If counsel has an integration like we do, we'd be able to see in real time, sometimes before you guys even do, when somebody goes into the system and changes their work site or their home address. So that can trigger an assessment. So it's whatever it is, make sure that you have some system to detect when there's location changes that could have an impact on what you need to do from an immigration perspective. We already talked about PAF. I won't go in that again. Perm recruitment, that's an area that everybody is talking about because it's become so hard these days to get people through perm. They're still being filed every day, but there are more applications being received for a lot of requisitions than there had been in the past. There's more scrutiny, there's more audits on perm filings. It's really important to maintain clear, compliant documentation so that if you get an audit, you can just hand that over to DOL and not be concerned about any kind of activities, any kind of issues with disqualifying somebody for reasons that weren't perm compliant. Make sure you have a front end process so that you're ready on the back end if there's an audit, because those are increasing. We already talked about terminations. And so one of the newer areas that people are talking about is the H-1B and perm consistency. We know that DOL, USCIS is starting to use AI to detect discrepancies, to identify instances of fraud. According to the most recent release data, they're limiting it to certain things like asylum claims. But that doesn't mean, that is the most up-to-date thing. And we have to assume, especially with perm, where the adjudication timeline could be 2 years, that by the time they get to reviewing that perm application and all those requirements that you put forth, they might be reviewing it against what you filed on the H-1B. Keep in mind, we have a new I-129 form where all the H-1Bs are filed on, and that now requires you to list the requirements for the role. So if the requirements for the same role are not the same as what you said on the perm application, that can create a discrepancy. And it's still an open question how USCIS or DOL is going to treat those kinds of discrepancies. Historically, those mismatches haven't really been scrutinized, but now a lot of companies are thinking, how do we proactively prepare for that type of scrutiny, because we know that we think that it might be coming. So in my advice is to start by making sure, even regardless of what size company you have, start working on a job bank. Have consistent job descriptions and requirements for roles by career band, by level. Sometimes you'll have somebody, for instance, a software engineer, and they might have a more specialized role from other software engineers, but you have to distinguish those roles. You can't just file perm or an H-1B with exact same cookie cutter job descriptions if the requirements for that role are going to be different than your standard requirements. So you have to approach your program holistically and strategically, not just looking at it on a case-by-case basis, because what previously was sort of siloed immigration. Now we have to assume that the government is going to be looking at disparate cases and even disparate agencies, DOL and USCIS, and comparing them to each other. So that's probably one of my number one points of advice within the last 6 months is start creating a job bank. Aizada, you came off?
Just wanted to say that we have 9 minutes left, so I want to be mindful of
Yes.
the time. You're about to finish, and maybe we go over questions quickly. Before we go over questions quickly, if you ever need our support, how we help is that, and how Alma is different if you ask from traditional vendors, is that for us it's attorney-led, AI assisted. Our AI actually assists attorneys to be more augmented and to deliver better strategy and better outcomes for clients, and that they also can spend more time with you. It's entirely attorney-led. You don't work with paralegals. You always can be confident that the advice that you're getting from attorneys is, a legal advice. Then the ownership end-to-end and execution. We, starting from the very assessment until, that a person gets a visa, we own every single step. And because all of our SLAs are visible on the platform, you don't have to worry that things fall through the crack. Every next step has timeline, like days when it needs to be done and who is responsible, so that you know exactly what's the next step. And then the other one is that just clarity for everyone. It's 100% clarity for employees. They see it. It relieves all the anxiety and they have. It's no longer black box for employees, but it's also unprecedented visibility for global mobility managers, HR teams, people teams, finance teams, everyone who wants to have a view. And we on all of our visas, 2 weeks usually is a turnaround time for us once we collect all the evidence. And then we have a 90% approval rate across different visas and including extraordinary visas. And then NPS score is 86. Essentially, this means that 9 out of 10 people we've surveyed who've used our services, they are a strong promoters of Alma. That's what NPS means. So if you need anything from us, please ping me on LinkedIn. Please ping Jihan. Happy to help out. Thank you so much who's attended and stayed. Thank you so much. It's a great attendance. We really appreciate it. Hope it was helpful. If you need anything, please reach out and we'll be sharing the deck materials with you. Thank you all and have a great Thursday ahead of you. Bye.